This is Mark from A. Brown ESQ LLC, and welcome to part 3 of our review of Quevy versus Commissioner. For those of you watching Tax Chronicles for the first time, I will again remind the viewers that this is the series where we review tax court opinions and just try to break it down so the average Joe can understand why the U.S. Tax Court determined the way they did in these opinions. So picking up where we left off, Quevy, this petitioner has been going through hell. I mean, she was diagnosed with a mental health illness. She was assaulted at work. She's working from home. She loses her insurance, all sorts of financial pressure. She's diagnosed with breast cancer, and then she gets hit by a car. I mean, this person is going through it. She's in the tax court. They're challenging the deduction she took under Section 104A2, which allows you to take deductions if the expenses were related to either a physical injury or physical illness. But now the tax court, despite all these crazy facts, want to challenge the deduction she's taking because they want to look at the settlement agreement. They're citing all this case law that puts heavy emphasis on the language used in the settlement agreement. And unfortunately, the settlement agreement did not make mention of her physical injury or any of the sicknesses like cancer that she was dealing with, let alone the mental illness that she was diagnosed with. Unfortunately, yes, what we were afraid of happened. The tax court ended up disallowing her deduction. They determined that her deduction should not have been taken because of the language that was used in the settlement agreement, because the settlement agreement did not make mention of her physical injuries. It specifically was setting forth that the payment that she received in the settlement agreement was severance compensation, and that it was due to her wrongful termination. Now, I have the highest regard for the judges at the tax court, and I absolutely respect their decisions in these opinions that they write. And we here at A. Brown ESQ LLC, we study these opinions. These are some of the brightest minds in the country, in our humble opinion. But I do respectfully disagree, and here is why. If you read Section 104A2, I'm going to read it to you. It is saying specifically, except in the case of amounts attributable to and not in excess of deductions allowed under Section 213 relating to medical, etc. expenses for any prior taxable year, gross income does not include the amount of any damages other than punitive damages received, whether by suit or agreement, and whether as lump sums or as periodic payments. Here's the key words. Viewers, listen. On account of personal physical injuries or physical sickness. My humble opinion is that I think the case law was extremely important for the tax court to take into account. But when you have facts in a case like this, I mean, personal physical injury. She was assaulted at work, and she was already in a fragile mental state. Physical sickness. There's been studies showing that high levels of stress and anxiety can make you more susceptible to diseases like cancer. In my opinion, this is exactly the type of petitioner that those who were drafting these laws were trying to allow to make deductions when it came to their medical expenses. Was the payment a payment for wrongful termination? Sure, but it was her physical state. It was her mental health condition on top of the getting assaulted, on top of the getting diagnosed with breast cancer, on top of getting hit by a car. I just really think that the judges at the tax court on this case, I think that they were a little bit too rigid on their analysis. In fact, one of the cases that they cited, which is Blum versus Commissioner, in part stated, quote unquote, I'm quoting their opinion, damages are on account of personal physical injuries or physical sickness if there is a direct causal link between the action giving rise to the damages and the physical injury or physical sickness. I mean, this type of language, I personally think there was a strong link between the action that was filed and not only the physical sickness, which was the cancer, but also the physical injuries. I mean, she got hit by a car. So I'll get off my soapbox, but I do think in this case, I did disagree with the way the court ruled. I thought, at least in that prong of their analysis, there was more to the opinion, but that's what I wanted to focus on today. But feel free to share your thoughts. I mean, we at A. Brown ESQ LLC, we would love for this to become a dialogue. Feel free to share your opinion in the comment section. But please, hit that like button, comment if you have an opinion, and follow A. Brown ESQ LLC's TikTok page. You guys, as always, happy holidays, and we'll see you in the next video.